Today we discuss the Employment Equity Act and regulations that have recently taken effect. This has massive implications, existential implications even, for businesses across South Africa. Whether you're an international business or a local business, what you do now matters a lot for your company, for your shareholders, and for society at large. My name is Piet le Roux, Chief Executive at Sakeliga, and with me in the studio today, Jaco Swart, the National Manager at NEASA, the National Employers Association of South Africa. Just last week, Sakeliga and NEASA, who are co-applicants against these regulations in a law process, lost a court case in an urgent interdict. We need to discuss the implications of that, what we're going to do to turn that around, and what businesses can do to minimize their risk and maximize their ethical conduct. Jaco, I'd like you to tell us about the finding last week by the Pretoria High Court, and we'll get into what we'll do about that later. But then once we've established what the situation is now for businesses watching this and what they need to do in the next few months, then we can get to the next. So please tell me, what was the decision last week?
Yeah, thank you, Piet. Yeah, well, the judge decided that, well, what he in essence says he doesn't have the power to grant an interdict. He said that because the minister already made a decision and already gazetted the regulations, the ship has sailed effectively, and he can't do anything about that. That is patently flawed, in our view. The Constitutional Court has, in many occasions, stated that the court indeed has the power to interdict such actions. But we'll discuss the process on that going forward a little bit later. The effect of that, like you mentioned, is that as of 1 September, these regulations is now law, and employers need to comply with them as far as practically possible. And that is what we need to discuss. So what we propose that employers do is to comply, as I mentioned, as far as practically possible, but to take certain steps in order to minimize their risk from a business point of view. So our advice, first of all, is that employers need to keep on employing on merit. It does not make sense for any business to employ people who don't have the required skill based on their gender or skin color. That should not be a requirement. Business must employ the best person for the position, irrespective of skin color or gender. So what we propose is that the first step of this whole process is that your employees must, according to the regulations, self-classify themselves according to gender and race.
So yeah, the practical step here is that to get to these new quotas by the minister, she's defining what your targets on your employment plan should be. We're going to discuss employment plans soon. But to even figure out what the racial composition of your current staff is for these quotas later on, they need to fill in a so-called EEA1 form. That's a form where they supposedly self-classify a race and some other classifications. Do they have to complete this form?
So the problem with the form is, of course, how do you classify race? What's the criteria?
And the minister has not given any information. There's nothing in law.
No, there hasn't been these types of racial classification laws since the apartheid years. So while there's an obligation on employees to complete the form in the sense that they need to complete their details and sign the form and date the form, there doesn't seem to be an obligation to classify yourself racially, based on the fact on how do you do that? Which criteria do I use? So although it may be a lawful instruction by an employer in terms of the regulation to state you need to complete the form, it might not be a reasonable instruction to say racially classify yourself.
And even whatever is completed there, if the employer agrees or disagrees, on what grounds? So now we're creating legal obligations or not obligations, but legal risks for the employer as soon as he wants to dispute a form. So he's liable for the accuracy of his employees. And they can, if he disagrees with that, there can even be a legal dispute there. But there's also the possibility of a legal dispute with the minister. So it's actually quite unreasonable for the minister to expect this. But this seems to be a complication.
It's very much a complication. And it goes even further. Like you said, then there's an obligation on the employer as to where employers either did or did not self-classify themselves, where they did classify, whether he's going to accept the classification or not. That's the obligation. If he doubts the obligation, doubts the classification, then the employer has to do it. Yet again, on which grounds, on which criteria, what do I use? Or where employees refuse to self-classify, the employer must classify.
Okay, so there's a big uncertainty and a risk there. The minister and the government, probably for obvious reasons, are trying to make this racial classification story the problem of employers, and we shouldn't willy-nilly accept that. So how do you at NEASA, because you're an employers association, you work with labor law every day, you're thousands of times in court helping employers on CCMA cases, but also on big other cases, so you know this stuff. How can employers mitigate this risk as relating to the classification?
So what we propose is that you classify your employees based on whatever you think is correct, whatever that might be. The regulations states you need to use historical or current data. No definition of what that is.
So you do what you think you need to do.
You do what you think you need to do. I don't know if you need to just look a person in the eye and say, well, I think you're white or Indian or I don't know. Whatever, I don't know what it is. But then on your EEA 12 form, which is a workforce profile, insert a caveat that says, I've tried to do this, I've done it to the best of my ability, I cannot guarantee that the racial classification is correct. And on your EEA 13, which is your plan, state, I've inserted these targets, they are irrational, they're arbitrary, I've only inserted them because I have to. And then even go further after you have filed your submission, to write a letter to the Director General and say, listen, I don't know if this is correct. I've tried to do it. I don't know if the classifications by my employees are correct. Please give me guidance. Show me how must I do it. I don't know how to do it. And yet again, say these targets have been inserted into my plan, but I only inserted it because it's under force and duress. I've got no choice.
This is important. So employers are being put under duress here. This is not a voluntary action. It's not. They don't have to set targets. They're being given quotas, and they're being told to fill in the quota. So this brings us to the employment equity plan that you have to submit. So you have to do this racial composition figuring out thing, and then you have to present a so-called employment equity plan.
That's correct.
To the Department of Labor, and that is supposed to be valid for the next 5 years. How does that look? How does that work under these new quotas?
So technically all that changed is that the way you set your goals. The rest of the plan deals with barriers and stuff like that, which has always been there. In the past, you could have set your goals over the 5 years, or 1 year, doesn't matter. You could have had a 1 year plan. So now it's a 5-year plan. But you could have set your goals according to your own unique business situation and the sector you operate in. If you don't have attrition or foresee not going to have attrition or growth or promotion or whatever the case might be, you could have set your targets in line with those expectations. Now, in terms of the regulations, you need to set your goals in an attempt towards the 5-year target. Remember, there are no targets set by the Minister for year 1 to 4, only year 5 in 2030. But you must set your years 1 to 4 targets in an attempt to reach towards.
So voluntary targets for year 1 to 4. Year 5, you fill in what the minister says, as if that's also a target, but it's actually a quota.
Yes, correct.
Okay, but so there's a risk now because let's say you try and you're here and the minister says let's say you have half your senior staff as white males and the minister wants it at 4%, which is very often the case. Like in 25% of industries, that's the case. So now you have to show in year 150, then you go down 10% a year until you end at 4% or something. If you do that, then there's an additional risk. You're compromising yourself voluntarily in the first 4 years. You're not only going to have to fight the minister's targets, because if there's a court case or a fine or a penalty against you, you now have to to explain why you didn't meet your own targets.
Yeah, absolutely. So that's why we advise that set targets that are sensible for your business.
What you want to do anyway.
You can achieve and prepare yourself to be challenged. Get your justifiable reasons in place to show to a labour inspector, this is why I'm setting this target, because it's irrational and unreasonable to expect to reach other targets or goals. It's not going to happen. And as you well know, you cannot dismiss employees in order to reach employment equity targets, even though there's a narrative out there that you're supposed to do that. You're not, by law, not allowed to do that. So unless there's massive growth in your business, it's not going to happen. So it does not make business sense to set targets that you're never going to reach.
Yeah. Okay. So the first part that we discussed that concerned the classification process and how to minimize your risks there, is saying that you're doing it under duress and giving it a best effort. And of course, it's also possible for, I've heard of people saying, I'm not going to comply in any way. Unlawful instructions and harmful governments all over the world have had to face people who just say this far and no further. We're not going to comply. There are risks there, and you guys can help minimize those risks. But it's also, of course, possible for people to be martyrs. But maybe it's better. It depends on case by case. Your guys' assistance are going to be how to minimize your risk, how to maximize your ethical resistance.
Yeah, I think you need to navigate this as carefully as possible and not be a martyr. Don't fall on your own sword. It's easy to say, I'm simply not going to do anything. But that's just going to make it easy for the department to issue compliance orders, get court orders against you, which might risk the survival of business in any event.
Okay.
So it doesn't make sense.
So another possibility here is that people restructure their businesses. That's also a risk mitigation thing you can do. There are upsides and downsides to that, I suppose. Tell me about that as an option.
Yeah, so obviously some employers have already indicated that they will simply split their businesses in order to fall below the 50 employee threshold. But of course, it comes with financial implications and administrative implications. And it's not a long-term solution. It hampers growth. You can never grow that 2 companies, 3 companies, 4 companies beyond 50. You're going to have to split them forever.
Yeah.
So long-term sustainability does not make sense.
Also, I mean, in Namibia, this kind of nonsense that was also implemented a while back, and they just dropped the threshold to 10. So it's 10 right now in Namibia.
Yeah.
And there's often, these politicians learn from each other. They don't seem to learn anything good anywhere else, but they learn from bad practices. Yeah. So it's just unfortunately foreseeable. Like Minister Nkosazana Meth said in Parliament recently, she's going to push transformation down the throats of businesses who don't want to do it, who don't want to do business not off a spreadsheet. So we shouldn't take comfort in whatever relaxation we are granted by the so-called king or queen right now. It's unlawful in our view, and we're going to argue that in court. We'll get to that. But it's also unethical and deeply immoral, and it's very harmful to society. If all businesses try to do this, it's impossible. The numbers don't exist to do this. So even if businesses wanted to do this, or family businesses are willing to give up their family character, which is unacceptable, but even if they were willing to the extent that some businesses comply, it'll be more impossible for others to comply. So we're really at a point of safety in numbers for the next 5 years. Even though companies some will pretend to comply, some will do their best to minimize their risk with some kind of minimum compliance and so on. In the end, 5 years from now, it's physically impossible for the majority of companies in this country to be operational and in compliance with these so-called targets, which are quotas.
Absolutely. Like you said, the numbers simply don't exist. If you look at some of the targets in for example, education, the education sector, if you don't grow that sector exponentially, you need to get rid of about 50,000 women to reach the target.
Yeah.
And employ the same amount of African men.
Yeah.
It's a simple impossibility. The pipeline in education of people studying education, it's not men, it's women.
Yeah.
So how are you going to do it? The skills simply aren't available. So I think you're right. So there's safety in numbers. By far the majority of employers will not be able to meet these targets.
And the most striking part of these regulations are how they reduce white males to 4% maximum in about 25% of cases, industries, job levels. And then, but the axe can fall on anyone. Like it can fall on women in some sector because they're so-called unrepresented or on males. You mentioned education, but transport is another one. Women don't want to be truck drivers. Men do that. And these politicians simply don't care. It's actually the most disrespectful thing you can possibly do toward a whole society and to the individuals in case, but they don't seem to care.
Absolutely. Some industries are simply more gender-based, like transport that you mentioned. I mean, I think out of the transport sector, your heavy-duty trucks, I think there are about 65,000 truck drivers registered with a particular bargaining class, of which 900 are women. Yeah. So how does the government expect anybody to reach those targets under those circumstances?
Okay, so these guys are down an ideological slope, and they want us to crash down there with them.
Yeah.
We're not going to do that. We're not going to stand for it, and we'll close with our next steps overall. But just take us through the next steps in terms of the litigation process.
All right. So as we mentioned earlier, the interdict application which we brought has been dismissed by the court, wrongfully in our view. But that was a two-part application. The first part was the urgent interdict to prevent the implementation of these regulations and targets as of the 1st of September. The second part is an application, a review application, to actually set aside the decision by the minister to actually gazette these targets. And secondly, to challenge the constitutional power or the power afforded to her to do this constitutionally. We do not believe it's constitutional for her to do it in the first place. And then secondly, what we'll be doing, we will be appealing directly to the Constitutional Court
on the urgent
interdict.
Okay.
We believe that judgment is deeply flawed. It hasn't taken into consideration long-standing jurisprudence, even rulings by the Constitutional Court itself as to the powers of the High Court. There's a massive lot of procedural deficiencies in the process the minister followed. There is a public interest component and constitutional rights applicable here. So we are quite hopeful that it will attract the attention of the Constitutional Court and they will grant us leave to appeal directly.
All right, and our attorneys, your and our attorneys together are working on this, drafting this right now. In the next week or two, that'll be filed and that'll take its course.
Yes, correct. We only have 10 days to file that leave to appeal.
Yeah.
So our legal team's already busy with it.
All right. Now, unfortunately, there is harm now already. I mean, even before 1 September, there was some harm. Now there's more harm because businesses have to figure out how to deal with this. They have to spend lots of money on consultants and time and management time figuring this out. They also have to possibly start restructuring their businesses. Those who start doing that, that's very expensive. They have to maybe not appoint some people that they were going to appoint because that's going to ruin their numbers now. So it's a massive implication already. And it's terrible, actually, that the court is willing, the Pretoria High Court is willing to let this harm take place. But we're going to fight that within the next court cases, as you said. We do have a little bit of there are ways to mitigate these. We've discussed some options initially. There's a final one I want to ask you about. There is some leeway in the time by when these employment equity plans, so-called plans, should be filed. Do we have to file it this week or yesterday, or do businesses have time?
So you do have a little bit of time. You can file technically as of the 1st of September, but the online filing system only closed on 15 January next year.
Okay.
So there is time for employers to consider what they want to do, to properly think about it and to make wise decisions before they submit those reports.
And minimize some of the damage that is now inevitably going to take place.
Yes.
Okay. That's good. Jaco, let's close this off by we discussed what you can do to minimize your risk. We discussed what people can do to maximize their ethical resistance. And then we discussed what Sakeliga and NEASA will do with regard to litigation. I think one thing that I want to emphasize from Sakeliga's side, and I'll give you the closing word on this, is that we are never going to accept these regulations and this act. It is disastrous. It is an existential question. It is impossible to comply with, but to the extent that we let the politicians pursue this and try and force businesses to comply, to the extent that we let them do it, we will be harming society and we will let them harm society. So from our side, Sakeliga and NEASA, we've decided that we will never accept it. We're going to keep resisting the expansion of it, and whatever gets implemented, we will continue until we overturn it. And that may be a multi-year process, but that's what we're here for, and that's what we're going to keep doing. And the right thing to do is to resist this in any way you can, while minimizing your legal and other risks, because it's also important to stay in business, because keeping this economy going is also what we're going to need for turning around these kinds of harmful ideological projects in the future. Last word to you, Jaco.
Yeah, thank you, Piet. Yeah, no, I agree wholeheartedly. We cannot allow government to continue to over-regulate business, and allow them to continue on this drive to socially re-engineer society according to their vision. It's time to stand together. We have to stop this. We can't be a functioning, growing economy with these types of bad policies and legislation in place. So stand up, fight, stand together, and we will not give up this fight.
Jaco Swart, National Manager at NEASA. My name's Piet le Roux. I'm from Sakeliga, and thank you for your support, and all the best with your own efforts at doing the right thing.